June 2008, the Supreme Court lifted D.C.'s 32-year-old gun ban, an outright ban on all functioning firearms anywhere in the district, a ruling that gave Dick Heller a place in legal history.
After 20 years of living like that, I could simply no longer do nothing anymore.
The Heller decision day was every bit a circus, marked by protests, news conferences, and a triumphant Heller addressing crowds. D.C. officials weren't happy with the decision, but still control the city's guns. And with individual gun rights in place, Second Amendment activists have been watching the district's every move.
Once I realized that the Heller decision was a trigger for nationwide gun bans, challenges, and I said, oh, this is wonderful. It's bigger than I thought.
The landmark Heller decision answered a narrow but centuries-old question. Can an individual own a firearm? Well, the Supreme Court's answer was yes. And not surprisingly, the gun rights community considered the decision a victory. But even Mr. Heller and his team realized the decision does not settle or fully address the entire issue of gun control. How has your life changed? This was a groundbreaking decision, 30 years in the making.
Well, we went from a very quiet, arduous, head in the books kind of life to one after the decision where once we got the favorable decision, people were very interested in talking to us.
Heller is referring to longtime legal partner Dane von Breckenruckert, who's been on the hunt since the decision. The district already backed off lingering issues over semi-automatic gun registration and storage requirements, something von Breckenruckert attributes to a lack of gun expertise on the part of the D.C. Council.
No rhyme, no reason. Two guns made in the same factory. One of them has one writing on them, the other one has some other kind of writing on them. Both of them are identical, made on the same assembly line. The city will register one, they won't register the others.
In June 2009, D.C. police added more than 1,000 guns to the list eligible for registration. The D.C. Council says decisions like these are to streamline the registration process. As chairman of the Committee on Public Safety and the Judiciary, Phil Mendelson's the most active council member on gun-related issues.
And I think there's a lot of misunderstanding about the purpose of registration. The purpose of registration isn't to try to get criminals to register their guns or to prevent law-abiding people from becoming criminals. The purpose of registration is to make it easier for the police to arrest criminals.
Since last summer, D.C. Council has been trying to pass a comprehensive crime bill, making it easier to convict offenders for having guns in their cars and using them in crimes. The bill was adopted in June 2009, set to expire in the fall. But Mendelson's biggest worry, a congressional amendment repealing the district's authority to regulate guns on the highly debated D.C. voting rights bill.
There's no state or local legislature in the country that lacks authority to legislate with regard to guns. It really is a stunning irony in the name of democracy to give us a vote in the House, but in the name of democracy to take away our ability to legislate with regard to guns.
The amendment has all but stalled the district shot for a vote in Congress, but Mendelson says the residents he's talked to don't blame the city council. Heller may have been an historic legal victory for the gun rights community, but they're not stopping there. They say they want gun rights to apply outside the Beltway. George Washington University professor Robert Cottrell is a Second Amendment expert.
I understand that within the gun control community that the district's decision to even fight Heller was looked at with a considerable degree of skepticism, simply because there was very much a fear that this would set a definitive Supreme Court precedent on the Second Amendment.
Justice Scalia's majority opinion in the Heller case left unresolved a separate question as to whether the Second Amendment applies to the states. So the gun rights community is suing cities across the country over a legal process called incorporation. They say the Second Amendment should be applied to the states through the Due Process Clause of the 14th Amendment, saying no state shall deprive any person life, liberty, or property. As soon as Heller was handed down last year, gun rights activists sued Chicago for its ban. The Seventh Circuit Court ruled the Chicago ban is constitutional.
That's the big enchilada right now, and Los Angeles will be next. But all we have to do is win in one. Once we win in the Supreme Court, everybody's going to have to get in line. At that point, people can't act like Chicago and say, well, we don't have to go along with that because it's not incorporated. Okay, well, we'll just see about that, and we will. And I am confident that we will prevail.
On September 30th, 2009, the Supreme Court set the stage for perhaps another historic ruling on gun rights by agreeing to hear a challenge to Chicago's ban early next year. The Chicago decision will involve new Supreme Court Justice Sonia Sotomayor, who's already ruled the Second Amendment does not apply to states. During her confirmation hearings, she said she would have an open mind on the incorporation issue, but will continue to follow Supreme Court precedents until it changes.
We continue to take the city to court because of the impediments and infringements on our Second Amendment rights.
There's a more fundamental issue, which is whether the court's decision in the Heller case applies only to the District of Columbia because we are not a state, and I don't know how the court's going to rule on that.